When you're ready, call the funeral home you prefer and make your appointment. Naturally, we suggest you to call the funeral home who have been in business for about 110 years. We are open 7 days a week to make pre-arrangements, including weekends. You can arrange your funeral in advance at the funeral home or at your house or apartment if you prefer. We do make house calls. If you want to just put your wishes on file at the funeral home, you can. If you want to pay for the funeral in advance, you can. You may start off with an initial payment of $500 and add to it whenever you wish. The money is placed in a bank account in your name and trust for Gleason Funeral Home. Your money is FDIC insured, and the funeral home can't touch the money until the death occurs. This is New York state law, and it's the best protection for the consumer in the country. Also, you're allowed to transfer your pre-plan from one funeral home to another. For example, we received quite a few transfers from St. Luke's and St. Helens parishioners when Fredericks and Quinn Fogarty's were sold to the national chain. The pre-planned account collects interest. The net consumer yield for August 2022 is 1.28%. If you are not receiving Medicaid, you can get your money back with interest at any time. The money is placed in a revocable account if you are not receiving Medicaid benefits. If you are receiving Medicaid benefits, the money has to be placed in an irrevocable account, which means whatever money is put in this account has to be spent on your funeral. If any money is left over in this account, it will be returned to the Social Service Department of the county you live in. There is no limit how much money can be paid for a funeral if you're receiving Medicaid benefits. It is perfectly legal, exempt from the nursing home and the government. A question we've been asked sometimes is, what happens if Gleason's goes out of business? This question brings to mind a woman named May. I had just received my funeral director's license in 1979 when a friend of my family came up to me after church services and said she wanted to make pre-arrangements, which she did, and paid for everything. She was 75 years old. Every year she would call me to update her file. One year she would add a him, another year another clergy person. In 2005, 26 years later, at the age of 101, she called me to ask, what happens if something happens to me? I started to laugh while saying at the rate that you're going, that's a possibility. But don't worry, your funeral is FDIC insured and transferable to any New York State funeral. 5 years later, at the age of 106, she passed away, and we took care of the funeral arrangements and honored all the requests. We take care of cremations, funerals, and entombments. If you decide on cremation, the Catholic Church now allows it. You can have a wake and service at church and then cremate. Cremains are a perpetual responsibility and should eventually be buried or placed in a niche. We recommend if you make your funeral arrangements in advance, there is a new agent form you should fill out. This form is for your funeral arrangements only. The person you name as your agent is in charge of your funeral arrangements only. You should print on the agent form if you want a mass, or especially if you want to be cremated. If you don't have surviving relatives, a friend, neighbor, priest, pastor can be your agent to make funeral arrangements. The importance of prearranged funerals was especially shown during the COVID experience. Families that had prearranged their funeral had already secured a cemetery plot and prepaid their funeral. They didn't have to come to the funeral home to make funeral arrangements during the COVID epidemic, as all the choices were made in advance. On the other hand, people without prearrangements had to wait 2 weeks just to buy a grave in some cemeteries, which had reduced hours and were overwhelmed. All our funeral directors at Gleason's Funeral Home have years of experience and training and are available 7 days a week. Also, there's no charge to make pre-arrangement. if anybody has any questions, feel free to ask me, John Golden. Vince Carey is in the back, our funeral directors, and also Jesse Luciano is also in the back. At this time, we'd like to introduce Ann-Margaret Carrozza, a nationwide respected elder care estate planning attorney. We're very fortunate to have her here today. Let's welcome.
Hello, everyone. It's a great, is this better? It's a great pleasure to be back here in person with all of you, so many of whom I haven't seen since before the horrendous 2 years we are hopefully finished with. What I want to talk to all of you about today, and please interrupt me by raising your hand if you have any questions. As we go along, I want this to be an interactive seminar. I want to talk to you today about legal protections for our property and our families. There are hundreds of laws that exist to protect us, but only if we know about them. So let's start with, what are we trying to protect our family members and our property from? Legal liabilities, long-term care claims, taxes, estate taxes, capital gains taxes, financially ruinous breakups, a child who gets divorced, and how does that impact property that they may inherit. So we're going to talk about all of these protections, not the least of which we need to be focused on are lawsuits. You can't have the TV on for a half hour without seeing an ad for some, 1-800, my arm hurts. And when we have a period of economic wobbliness, lawsuits go up. There was an article this past week that in the city of New York alone, lawsuits against the city have increased 22%. And as an aside, some of you know this, my late grandmother was a trip and fall queen. This was a little bit of a side hustle for her. And there was rarely a family wedding where she didn't have a few too many cocktails and would take to the floor. And those of you who are old enough to remember Charo at her heyday, my grandmother had a very good hoochie coochie dance back in the day. And invariably she'd have a slip and there would be a lawsuit. And every time I passed what was the Amber Lantern, I feel a little bit guilty. It may be just a coincidence that they went out of business after her lawsuit. And I suspect that lawsuit money helped pay for my braces back in the day. So I think it is good that I make my life's work educating people on protecting assets. So let's start with real estate. And may I ask by a show of hands, how many folks here own a home, a condo, or a co-op? Okay, that's the overwhelming majority. Nationwide, 70% of us own real estate. And I think if you take nothing from today, remember the following. I think it is crazy to own real estate in our own names. We are sitting ducks. This information is publicly available with the push of a button. Back in the day, my family would keep the deed in a tin box up in the coat closet hidden. But now anyone can get it at any time. And that makes it very easy for people to sue us and for a nursing home to put a lien or a claim on real property. There is a widespread, it is true, but it's only partial of the story. The house, and who has heard this? The house is exempt from a nursing home. Has anyone heard that? The house is exempt, and listen to the whole thing. It's exempt from Medicaid eligibility. Okay, I can get on to the Medicaid program, or my husband can get on to the Medicaid program, even though we may have a big, beautiful house. Okay, it's exempt on the front end. So they give us enough rope to hang ourselves because it is not exempt on the back end. Upon my death, who gets my nice house? The nursing home wants their pound of flesh, and they will put a lien on the property. So in order to prevent that from happening, we need to do some planning with the real estate. And whether it's our primary residence plus a vacation property, primary vacation plus a rental property, however large our real estate portfolio is, we need to protect it. So let's start with, what do most people do to try to protect their house? Okay, I'm hearing a lot of correct answers, and that's the trust. But what most people are still doing is putting the house into the kids' names. Right, never, ever, ever a good idea. My kids could be the nicest people in the United States, and maybe I'm not worried that they're gonna put me out on my head, but there will be certain definite negative consequences. If I bought my house in 1978 for $50,000 and it's now worth $650 or $750 or $850 or Whitestone $1 million, that is all capital gain, right? And if I give it to you as my daughter and you're nice, you let me live out my days in the house, and you go to sell it later, you're whacked in the head with capital gains taxes. Number one. Number two, if I put my house in your name, I'm going to lose any property tax exemptions that I was otherwise entitled to. My late husband's partial veterans exemption, STAR, they would all go out the window because I put the house in the kids' names. And what happens if one of my darling children is in a divorce? What would happen? If half the house is in my son's name and he's going through a divorce, now my soon-to-be ex-daughter-in-law would have an interest in my dopey son's part of the house. And if all of that wasn't bad enough, if I have grandchildren applying for college financial aid and their parent owns part of the house, they're going to get less college financial aid. So it's never, ever, ever a good idea to take the real estate or the co-op or the condo and put it in the name of someone else. In my book, Love and Money, I tell the story of a guy who put the house in his daughter's name. Some of you know this story. They were as close as could be. He would trust her with his life. And he was right to trust her. She loved her father beyond measure. Does anyone remember what happened? The daughter died. And what did she not have? A will. She didn't have a will. And when we don't have a will, New York State has one for us. It's a formula. And it may or may not produce a good result in my particular situation, but the formula for this poor young woman who died in a car accident was that her husband received anything that was in her name. So the father thought, of course, the son-in-law is going to honor, what was an internal family agreement. A couple of months after the funeral, the son-in-law wanted to start dating again. And he thought it was going to be very awkward bringing new lady friends to the house with his late wife's father living there. So he suggested to his father-in-law that it might be, better for everyone if you made other arrangements. He was out of his house. So now finally, he went to a good attorney, and the attorney said, not only can't you do anything about this, you owe gift taxes because the amount that we transferred was more than, it was $10,000 at that time. Now it's $16,000. So this guy was just totally screwed, and whose fault was it at the end of the day? Yeah. You can never, and I'm doing this 26 years, and just when you think you've heard every crazy, wacky story, and you've seen the depths of human depravity and how people lose their brains and their moral compass sometimes where money is concerned, I see a new story and people are hitting a new low. We never want to totally divest ourselves of control. That is critically important. And there's never a reason to leave ourselves in a legally vulnerable position. So we want to think about, with the real estate, a trust. What kind of trust? You're all familiar with the two kinds of trusts, right? Revocable and irrevocable. For purposes of protecting the house, we don't want to be in either camp. A revocable trust is very appealing psychologically. You can buy a kit off of the internet. You go to Florida, you seem to come back with a revocable trust. Everyone there has these revocable living trusts. My mother sometimes goes to seminars. They have refreshments, and she might meet a nice gentleman, but hopefully she doesn't do a revocable trust. Because why is it appealing psychologically? Because I can be my own trustee, and I can put my assets in, and I can pull my assets out. No one is the boss of me. But think about it. If I can get my hot little hands on the assets whenever I want, so can my creditors, so can my soon-to-be ex-husband, so can the nursing home, on and on and on and on. So we want it to be a little bit of a stronger trust. We do not, however, have to go all the way into being a totally irrevocable trust. A totally irrevocable trust is as rotten as it sounds. You can't change anything. With a totally irrevocable trust, if I get mad at my trustee, I'm stuck with them. If I want to have the luxury of getting mad at the world and disinheriting my son, I'm stuck. I can't do anything. So there's never a reason to go that far. We want to be somewhere in the middle. And people ask me, what is this trust called? Well, what we call it doesn't matter as much as what's in it. What are the legal provisions that are in it? I can call it an asset protection trust. I can call it a family trust. I can call it a hybrid trust because it has elements of being revocable and a little bit of irrevocable. So here's how it works. I must appoint another person or two people together as my trustees. Okay. But if the trust is properly drafted, I will clip the wings of my trustees so they can't look left and they can't look right without my written permission. Number one. Number two, I retain the right for any reason or no reason to remove my trustee and appoint another person as the trustee. Okay, so if they don't really have any power acting alone, what's the point? What would be different if my house was in this trust? And there's one thing that would be different. If I want to sell my house, and again, the trustee cannot sell without me. So if I'm in rehab and I'm going on the 4th month of rehab and I still want to come home and my kids think they know best and they're going to sell the house to make me stay there, they're not able to do that because their signature alone is insufficient to sell the real estate. However, the one difference is if I want to sell the real estate, we need my signature and the trustee's signature. How does that protect the property? Well, 5 years after the day we set that up, I can say to the nursing home, I can't get at the house acting alone. And that is true. The trust is irrevocable to me acting alone, right? I can't get at it to pull my house out. And because I acting alone can't get at the house, neither can the nursing home. Now, playing devil's advocate, what if, and there would not be a good reason to do this, but it's important to know that we can do it. What if I wanted to pull my house back out and the trustee said, no, I don't think you should do it. I retained the ability to say, thank you for your opinion. You're not the trustee anymore. I'm going to pay the guy down the block $20 to be my trustee for 5 minutes and give me that second signature and put the real estate back in my name. So are we clear on how that trustee works? The trustee is like a placeholder or a bouncer at the door, and is there if I want them to be there to give me the ability to say to the nursing home, oh, look, acting alone, I can't get at it. I would love to be able to give you my nice home, the grand, but I just can't do it. That is what the trustee does. Yes.
Yeah, so, just to give you some props, I, bought my dad's yoga law firm years ago. And, we established an irrevocable trust for my dad. We legally impoverished him, all right, we put him into a full trust. Worked beautiful, thanks to your law,
Oh,
okay? Yeah, you're welcome. So that worked really well, okay? He was able to stay at home, die at home, and my family retained the rights to the property. So, all right, you're telling me that there's a hybrid trust now. Is that a combination of irrevocable and revocable trust, or?
Yeah,
that's. It is, right?
I can't speak to your specific situation, but the situation that you're describing was a hybrid trust.
Okay, so this is nothing new.
Well,
Because we were trying to protect him from Medicare.
Yeah.
Right, there was like a 3-month look back at that particular time.
For home care, yeah.
Right, that's increased now to like 2 years or something, right?
Effective January 1st. We'll get to that.
All right, so we got through the 3 months and he was able to stay at home. And as a consequence, Medicare couldn't come after his house. The government couldn't come after his house. Beautiful. The only thing is that he couldn't, that house was not in his name anymore. In order to sell that house, it would have to have his approval and the approval of the trustee. Is that correct?
That's right.
All right, okay, fine. I just wanted to make sure I had that straight.
You have it very straight. Yes.
You mentioned, you know, the cost of a certain amount of years.
Yeah. So you've all heard of a 5-year look back period. That means if I create a trust today and I put my house in the trust today, and I have the bad luck to need nursing home Medicaid tomorrow, it's not really gonna work. The government says, we're gonna give you a very valuable benefit, but you need to kind of fend for yourself for a little bit of time. And that time is now 5 years. It used to be 3 years. Those of you who did planning for your parents back in the day, it was 3 years. As of 2006, it went to 5. There's a bill in Congress to make it 7, but that hasn't passed yet. So anyone who does their planning under the current law would be grandfathered. So what does that mean? If I am unlucky enough not to make the 5 years, I'm still ahead of the game, because let's say I do my trust, I put the real estate in the trust, and 4 years goes by, and then I fall apart and need nursing home level care. Well, now my family only has to privately pay for me for that last 1 year. And it's no joke. It's $16,000 a month. You know, no one plans on needing nursing home level care. But sometimes it happens. We have an acute illness where Medicare and the Medicare supplement cover everything at the hospital level. When we leave the hospital and we go to rehab, Medicare and the supplement will cover up to 100 days. And the up to, I'm making air quotes because we're not guaranteed 100 days, but we are guaranteed that we're not going to get more than 100 days. And it's during that time that the family really needs to get in gear and make sure that everything is the way that it should be. Yes.
My name is Sonia. I'm for my ex-husband lives in Maryland. He wants to, I've been hanging over the age, but he wants to make the house and do the house in Florida. He's been living with his home for more than 10 years. They are not married, so they are together. I have a son. Now he mentioned that he's going to do his house, my house, and for their house and whatever. What would be I spoke about in the trust, but he didn't want to.
Yeah, you know, again, someone who wants to put real estate into a child's name, in that case, I would say, you know, I can't give individual advice, you know, from 20 feet away, obviously. But if I had an ex-husband with a live-in friend for 10 years, now I'm going to be very concerned that she's wheeling and dealing to get her name on that deed, and then my son's going to be out in the cold. In that case, if my ex-husband is allergic to the idea of a trust, now better that my son end up paying a lot of capital gains taxes than having him lose out on the property altogether.
My son was never
If this person did a trust and the property was in the trust and the child is the beneficiary, now we've avoided probate, right? And it's as simple as if my mother had a CD and I'm the beneficiary, all I have to do is go to the bank with a death certificate. They'll give me condolences and I will walk out with payment. I don't need a lawyer. I don't need to probate the will. So the trust will avoid probate for the son. But you bring up an interesting point, and we'll take a side issue on this. In a blended family situation, our planning antenna needs to be up, because we can have competing concerns between my adult children who hate my new younger husband and my new younger husband who hate my adult children, and they can kind of keep a lid on their mutual hatred during my life. But upon my death, there are going to be fireworks. And anyone in this situation, the young spouse is telling me, oh, put my name on the house, I'm gonna be out in the street. Of course, I'm gonna make sure that your kids get the house later. You can't believe that, especially if they have their own children. They're gonna want their children to get any property that happens to be in their name. So when it comes to this estate planning, one size does not fit all. You want the property to go to Mary, Susie, and Johnny? Fine. But how do you want it to go to them? Johnny hasn't worked for 20 years. Whose fault is that? Is it his fault? Or he kept having bad bosses who were bird brains, and now he's on my couch watching game shows all day. But whatever the right and wrong of it is, he's my son. I love him. I want him to have a third of my estate, but it would be foolish of me to let him have it all at once, because it would be gone in 18 months. He thinks he's a business genius. He's going to invest it in cryptocurrency, and he's going to be out, and he's going to be calling my other kids, making their lives miserable forevermore. So we can say Johnny gets a third, to be distributed to him at the rate of 5% a year for 20 years, or whatever kind of creative thing you want to come up with. If I have a child who has a developmental disability, who has substance abuse or gambling issues, there's not one of us here who has a totally normal family, right? And we all have some little dysfunction, but the definite thing is that my family dysfunction, and I have a lot of it, is different from your family dysfunction. So, part of this process is having a very frank conversation and trying to build structures. So to give you an example of a nice compromise that we can do for my husband Fabio and my adult children, and the adult children are saying, you have to leave us the house because you and our late dad bought the house, so justifiably that should be ours. And they have a good point there. But what if I am married to Fabio for 20 years? Do I want to leave him homeless upon my death? So the old solution to this problem, and don't take notes on this because it's a bad solution. The old solution was the house goes to Fabio for his life, and upon his death, it goes to the 3 kids. That's a mistake. To give him a life estate is a big mistake, because what happens if he leaves the house and he rents it out and he moves to Florida with his new friend? He gets the rental income and my kids get nothing. Or if he, God forbid, is in a nursing home, he's technically alive, but no one can do anything with the house because he's technically alive. So instead, what we want to do is a limited right of occupancy. And this is something nice to do for my kid who's living at home. He's on the couch, and I know when I die, he's not going to have enough money to keep up with the overhead of the house. Yet I want to give him a little grace period to get himself together before my other 2 kids are looking to push him out and sell the property. So what we give to my child on the couch and my husband Fabio is the right to occupy the property until the earlier of their death, their voluntary departure, or their permanent stay in a nursing facility, or if I want to be really controlling, or his remarriage. Okay, and then the right of occupancy extinguishes. They should be happy and well, but let them go live in her house. And at that point, the house reverts automatically to my kids. So that's an example of how we can come up with something that's really good without the downsides. Question? Yeah,
Let's go back to that 5-year look back.
yeah,
And you used the example that we put the property in trust before, we put the property in trust. 4 years goes by, I have to go into a nursing home. We are responsible for the fees of the nursing home. What happens in the 6th year?
okay, so
Who's responsible?
Medicaid. So,
Medicaid,
yeah,
so
Medicaid.
she's protected. My wife.
Again, I can't speak to your individual situation. Let's take money out of the equation for a moment, and let's say the only thing I own is a house. I put the house into the trust, a certain amount of time goes by. If I get caught short and need nursing home level care sooner than the 5 years, I need to privately pay for the remainder of the time. What if I have no money to do that and we want to keep the house? We can take a mortgage on the house. And, you know, your head is going to spin when I say the following words, but it's not always a bad thing. A reverse mortgage is not always a bad thing. If it allows the family to keep the house and not sell in a down market, it makes some sense to think about. And especially if the type of care that I need is home care. Under current New York state law, the home care program has no look back period. So anyone here today is by definition too well to need home care. But if anyone did need help with activities of daily living, the cranky functions of feeding, bathing, toileting, the kind of help that we will all need if we're lucky enough to live long enough. These are facts of life, and Medicare and the Medicare supplement do not give this level of coverage. When we leave the hospital and we go home, they'll give us a little bit of visiting nurse service, but that will conk out in about 3.5 weeks or so. And we want to be in a position to think about Medicaid. Now, yeah.
Yeah, I just want to clarify something. So if you keep somebody at home, all right, I thought that there was a 2-year look back period with
That's going to start in January.
Oh, so when you're talking about starts in January, that there's no look back period if
Right
someone
now.
stays at home
Right now.
right now.
So if you have a neighbor, a relative who could use some help, and you see the commercials are you can have your child, you can have your grandchild be a caregiver. You know, a lot of people hear Medicaid and they think Frankenstein is going to show up at the door to provide the care. In New York State, that's not true because they're concerned about liability. So only the top home care agencies have these Medicaid contracts. But you can hire your own person, a retired lady in the neighborhood. Let's say, you know, my mother doesn't really have medical issues, but we have a little cognitive impairment, and I'm concerned if she's alone. Well, the retired lady around the block doesn't need any particular medical training, that they can be with her, and Medicaid will pay for that. Now, as an aside, for the baby boomers amongst us, this Medicaid program is not going to be as good as it is in 10 or 15 years. Some of you know, by way of background, I was a New York State Assemblywoman for 14 years, and I can tell you that every year in the New York State budget, Medicaid becomes a bigger and bigger portion of the state budget pie. And it has recently taken over education as a fraction of New York State spending. So it cannot continue in its current form. But the program that is there today, for those of you who don't have long-term care insurance, Or if you have long-term care insurance, but it's not enough, if the benefit is $250 a day, well, if we need nursing home care, we need to come up with an additional $250 a day. So we're still applying for Medicaid. Under current New York state law, it is illegal for a nursing facility to differentiate between us because I'm on Medicaid and you're private pay. In New Jersey, they can have a two-tier care system. And they can say, sorry, Ann, we don't have any Medicaid beds. We'll put you on a list. But in New York State, you can have, and we've all been in lousy facilities, right? Visiting elderly relatives over the years and you leave crying. You can have lousy facilities or better facilities, but within the given facility, the care is 100% equal between Medicaid and private pay. Yes.
Question. So you're talking about asset as just real estate. What if you have liquid assets?
Okay, what a great segue. What about,
What was the question?
okay, what about other types of assets? Well, we start with the real estate in the trust because you will not feel the difference if the trust is properly drafted. And we're going to come back to this again. Your second category of assets are retirement accounts, 401k, IRA, TDA, 403b, whatever your retirement accounts are, that's already invisible. Did you know that? I'm not going to embarrass you by asking if we have any retired teachers here, but if we do, you have very big, beautiful TDAs. That is invisible to the Medicaid program. So that's important to know. So with the real estate and the trust, we're going to be good on that asset in 5 years. Your retirement accounts, we're already good there. And that leaves the everything else. What do we do with the everything else? Initially, my advice to a client is don't do anything with it, right? Because I'm telling you with the house, you're not going to feel the difference. If I put all of my money in that trust, I wouldn't feel the difference. Because I don't want to have to go to my trustee for money to go out to lunch. So leave the money outside, but make sure that we have a very good power of attorney. So where we have a husband and wife, or today I should say two spouses, where we have two spouses, they need to have power of attorney over each other. Because to close an account and move the money between themselves, they would need power of attorney. So let's say my 5 years is done baking on the house and the trust. My retirement accounts are already invisible. My husband has to go into a nursing home and we have $300,000 in the bank. Well, with the power of attorney, during the initial 100 days that Medicare and the supplement are covering him at the rehab, I'm going to go to the bank and I'm going to move the money into my name. Do we have a 5-year problem with that? No, because the 5-year look back does not apply between spouses. Okay, so you're in reasonably good health, and we have a husband and wife, let's say in our 70s, I tell them keep the money where it is, but the mental game plan is if someone gets sick, we want to move most of it to the well spouse. Yes.
I understand your point on the money visible with the retirement account. What about more distribution?
That's part of the income, and we'll talk about income later. I'm sorry?
For example, someone has a retirement.
Yeah.
And then there's a child. Something happens, I wouldn't know.
Okay, you're using an example of a retirement account in a nursing home. Nursing home can't look at the retirement account.
So if I take out money, slightly more money, for example, so I mean, I take out, so for my retirement account, or I can. Yes, it could be going, Social Security, because I would be entitled to get rid. If I take more money, it's become income, and then it's more than savings.
Yeah, so we have a few income questions. When we need nursing home level care, we can protect the assets by and large, but they would be entitled to my income. And my income includes multiplying my annual required minimum distribution from my retirement plan. We divide that rather by 12, and that result is fed into my monthly income budget, and the nursing home would get that. Yeah. Yes, sir.
If you make a change to an irrevocable trust, does the 5-year look back go back to the original date of the first trust or the second?
That is a question, you know, it's like a board game and the rules are written inside of it. It depends on the rules of that particular trust. I wrote an article a few years ago called, I thought it was so brilliantly titled, it was called Sort of Irrevocable. And it was for the New York Law Journal, you know, designed to be written for other attorneys. But the upshot is there are 3 ways to get into even an ironclad irrevocable trust. One is judicial reformation, and the other one is decanting. So think of wine, and we can decant it into another container. And the third one is statutory reformation under New York state law with the written permission of the grantor and all of the beneficiaries. We can modify and revoke even an irrevocable trust. So I would say that my general answer to you would be, we should be okay as long as we didn't break the magic spell by putting any of the money back in mom's name. Okay, so, and that applies to the real estate in the trust. If we sell from within the trust, the new buyers have to make that check payable, not to Ann-Margaret Carrozza, but to the Ann-Margaret Carrozza trust. Exactly. So now we didn't break the bubble at all, and they make the check payable to the trust, and this trust buys my new swanky condo or whatever it is. So everything should take place within this little turtle shell. Yes.
So, that's what you were just saying. So, all accounts of, let's say, liquid assets, not retirement accounts in the house. So you said they should always join the accounts?
No, I didn't say that at all.
Well, here's what I asked. The account is just in one spouse's name. They have a stroke tomorrow. They're incapacitated. You can't move those.
You need power of attorney. That's what I said.
That's in power of attorney.
Everyone needs power of attorney. And a lot of people say we're married, we don't need power of attorney. Or I can do the power of attorney on my own. Don't do the power of attorney on your own. There are plenty of things you can and should do on your own. On my website, which is myelderlawattorney.com, I have 3 forms. The things you can do on your own are there, just download them. A healthcare proxy, you all know what that is. I appoint you to make my medical decisions in a hospital if I can't speak for myself. As a former legislator, I can tell you that law was designed to be user-friendly. You don't need a lawyer for a healthcare proxy, and it drives me berserk when people charge to do that. That's just not nice. It's stupid. And the form that John Golden mentioned the appointment of an agent to deal with funeral planning, that's on my website. Download it, you can do it on your own. The power of attorney, however, you don't want to do that on your own. And you don't want, the real estate attorney around the corner to do it for you because it's going to be severely limited. And at the 11th hour, it may be insufficient to do the quick planning that we need to get done. Yes, sir.
You were mentioning, I'm referring to New York State law. If you have real estate property out of New York State, how does the trust or the same law apply to it here as in the other state, whether it be Arizona, whether it be Florida, whether it be California?
Yeah, because, we have so many retirees go to other states. More and more, all states are overlapping with the rules. But this 5-year look back, that's a federal law. So that applies in all 50 states. The trust that I'm talking about is a creature of the Internal Revenue Code, which is federal. So it applies in all 50 states. So we often have New Yorkers, more and more, we have New Yorkers selling the New York real estate and the sale proceeds payable to the trust. The trust buys the place in Arizona or Florida, or we may start off with properties in more than one state, and they can all happily go into the same trust. And it's critically important for us to put real estate in a trust if we have property in more than one state, because it's bad enough if the next generation has to go through probate in New York. You don't want them to have to do a double probate, New York and Florida or Arizona. So we definitely want to think about the trust to avoid probate. We can avoid probate on everything else in the world by listing beneficiaries. But the real estate, that is the only definite. The real estate would have to go through the will and would be subject to probate if it's not owned by a trust. Yes.
All right, when you're talking about the trust in real estate and 5-year look back, if I start off with one property and then I buy another one, do I have to set up a separate trust for it, or do I put it in the first and then is the look back 5 years for the first, and then the 5-year period starts separately for the second part of the newer property?
You have it logically perfect. Yes, good. So you can have different clocks for different assets within the one trust. How many properties can go in this trust? The functional limit is you want to stay below the current New York State estate tax threshold. We designed this trust to avoid capital gains on the property at death. If the house I bought for $50,000 in 1978 is now worth $1 million, and it goes to my kids through the trust, they have zero capital gains. All of the capital gains magically gets eliminated. The technical way, though, that it gets eliminated is through a journey into my gross taxable estate for estate tax purposes. And that journey is going to be cost-free, provided that we're under the current state estate tax threshold. And when I give you the number, you're going to roll your eyes and say, that doesn't apply to me, and it's 6.1 million. Don't roll your eyes, because my former colleagues in Albany are talking about lowering that to get some money for the state budget. So it's something to keep your eye on.
I'm a widow and I have a home and I have one son. What happens when I die?
Without a trust, he would go to court and he would go through probate of the will.
What would you suggest I do?
A trust.
Do I have to come to an attorney?
You should go to an attorney for a trust. Again, I think it is in 20 years, people are going to say, Really? You used to own real estate in your own name and you were just like a sitting duck? If the mailman falls off of your front steps, they're gonna sue you?
And my former boyfriend said, he's a lawyer, he said it goes to my son, everything goes to my son.
Yeah, how long does it take to go to your son? Look at Aretha Franklin. You know, can you do your own will? If we were on a game show, the answer would be, yes, I can do my own will. I can do a will on a bounty paper towel. There was a case we studied in law school. A guy wrote his will on the back of a kitchen cabinet, and it held up. The question is, how many years did it take for the son to get the property?
You suggest I see a lawyer and take care of that.
I suggest that you consider doing a trust. You know, that's the only definite I can throw out there. Yes.
If you would, like, co-op.
Okay. Anyone interested in the rules for co-op?
Yeah.
Okay. So, as you know, co-ops are allowed to implement any rules or regulations or prohibitions that the self-important board chooses to implement. They cannot, however, prevent me from doing asset protection planning. Do they have to allow trust ownership? No. And I would say about half of the co-ops allow trust ownership and half don't. For the co-ops that don't allow trust ownership, we have a workaround. And that is called a limited assignment of the economic value pertinent to the stock of the co-op. What does that mean? Well, in my will, if I leave my daughter or I leave my son my co-op, do they have to let him live there? No. If he collects rescue cats as a hobby, they don't need to let him live there. But when he finally finds a buyer that passes muster with the board and the unit sells, who's going to get the money? The son. So that is the model that we use to bifurcate the use, the occupancy of the apartment, which continues to be governed by the board. I continue to be held to the strictures of the proprietary lease, but I am legally assigning the economic value to the trust. This is a legally binding assignment, and it's legally binding on New York State Medicaid program. And it will get this 5-year clock ticking on the value of the co-op. Now, some of you will leave here and you will go to the management office and you'll ask them about this, and they will look at you like you have 3 heads, and they will just say, we don't allow trust ownership. This is not binding on the co-op. It's none of their business that you're doing it. And many people whose co-ops do allow trust ownership choose to go this simpler route to do away with the oversight of the co-op, because their attorneys would have to look at the trust, and that, you know, really runs up a lot of legal fees. So the limited assignment with the co-op kind of hollows it out. So I'm living in a beautiful shell, but the value has been pushed out of my name into the asset protection trust. Yes.
So in that, excuse me, in that situation, would you be able to find the answer to that in the bylaws of the co-op?
No, the bylaws simply give the board power to decide whether or not to allow trust ownership. And whether they do or whether they don't, under New York State law, you're allowed to do this limited assignment. And within the terms of the limited assignment, I say, this is not binding on Clearview Gardens Corporation, which shall continue to have oversight over the apartment. Yes,
Our co-op gave us a secondary option of adding a second person to your deed.
no good.
Oh,
To add my child to the deed on my house, or to add my child to the shares of stock of the co-op is the worst of both worlds. Because if the child gets divorced, my son-in-law gets half the co-op. If I go to a nursing home, the nursing home gets my half of the co-op. So that, I would definitely not do that. Yeah, that's the worst of all worlds. Yes,
Yeah, just getting back to the hybrid trust for a second. Now, one of the questions that I came in here with was there's people in my life that I trust very much, but I don't necessarily trust them to be a trustee. So you're saying that with this hybrid trust, we can put together a trust, put the house in a irrevocable trust, and I can also change the trustee when I want. Is that correct?
whenever you want.
Now, to get more information on this, should I make an appointment with one of your attorneys? Should I read your book or what? Is that stuff included in there?
The book, thank you.
I should be your agent.
I promise I'm not here plugging the book, but I do have a lot of good information in it. It's Love and Money, Protecting Yourself from Angry Exes, Wacky Relatives, Con Artists, and Inner Demons. Dr. Phil wrote the forward to it. It's on sale at Amazon or Barnes and Noble, a few other places. And the purchase price is a credit toward legal fees. If you buy it and you think it was lousy, I'm happy to refund the money. I mean it. I do think there's some valuable content in there because it's filled with stories of people who just had a piano drop on their head because they didn't even think, that something could be a possibility.
But to address my particular situation in the hybrid trust, I should really make an appointment with one of your attorneys, yes? Or-
I think it doesn't hurt to sit down and talk through the situation and say, here's what's going on with me health-wise. Here are my romantic entanglements. My kids, one doesn't like her sister-in-law. All of these things need to be discussed on the front end. What we're really looking to avoid is blended family or non-blended family warfare later. And the number one thing that causes families to fight and often to never see each other again. At my conference room table in Bayside, I have families leave after a parent's passing, and I say to myself, God help them, if their mother knew how they're leaving this office. My receptionist has had to call 911 on more than one occasion. Brothers trying to push each other through my office window. And this happens when something is not clear. So let's try to think about what could go wrong later on. Let's say I gave my daughter $100,000 toward a down payment on her house. And she was going to pay me back, and it kind of, just never happened. And my will says everything even Steven 3 ways. Well, my other two, how do you think they feel about the 100 that went to the daughter during my life? They feel it should count against what she gets in the estate. But she's saying, Mom wanted me to have that as a gift. So what's right, what's wrong? It depends on what I wanted. So sometimes parents are chickens and they don't really want to go there, and they say, oh, it'll kind of all work out. Or Another common scenario is I have 3 kids. One is chronically unemployed or underemployed. One is a neurosurgeon, awash in money. How do I deal with them in the will? And my advice is equally. If he wants to share, he will. If I want to give my daughter extra, I'm going to go to the bank, make a CD. She's the beneficiary of that. And I may or may not tell my son about it, but I'm certainly going to tell her about it. She gets some extra help. But in the will, last will and testament from the Greek, my last wishes, my last words to my kids through the will are, Mom loves all of you equally. And even the highly successful neurosurgeon, if he's getting 10%, I feel like his feelings are hurt a little bit. So let's give the people who need more extra help during life or off the reservation, so to speak, and the will should try to strive for family harmony. Yeah.
On that note, say the mom doesn't give it equitable, she passes, can the will be contested?
All wills can be contested. Where there's a will, there's a war. And it's very interesting historically, for the geeks among us, the law of wills goes back to the 1500s. And when you read through the language of your will that you have at home in a drawer somewhere, the language is a little stultifying, and that's because it goes back to Old English, it goes back to the 1500s, and the procedure for a will to be effectuated is called probate. So there's this big misconception out there. Why do I have to go to probate? I did a will. Well, the will goes to probate. We should all have a nice will, but the goal is not to have to use it. We want to avoid probate by having things passed automatically by operation of law. Yeah.
So, my mom lives in 2 houses, and she has 2 daughters. One of the house is very big property, master. The 2 houses, like, she doesn't need to rent out. But she put the will down, and she gave the big property to one of the daughters, and then the granddaughter. But she gave her name in the deed. But she didn't do other things. Now, after her death, is it possible to change that? Or is she?
No, we can't change things after someone's dead. Yeah.
With the deed?
We can't change a deed after someone's dead. Yeah.
But then she's alive.
Yes. Yes, sir.
And setting up the trust for the real estate, we have all heard, I'm sure, on the commercial on radio and TV about scams where people can access deeds and you don't even know if your property is gone until much later in the game. Does setting up the trust help include all of that possibility from happening by a scammer?
Well, look, there are brilliant scammers out there, and I see all manner of hijinks out there. But I think having a trustee between, the original owner and the property is, like a bouncer at the door, and it's an additional level of protection. I want to make one more point about the workings of the trust, the mechanics of the trust. I'm going to name beneficiaries, right? The 3 people who should take it upon my death. But it is critically important that I retain the ability to make changes. Will I ever make changes? Probably not. But because I legally hold the puppet strings and the terms of this trust that I'm reading directly from the trust, the beneficiaries are Mary, Susie, and Johnny. Per stirpes, that's Latin. That means if God forbid they die, it goes to their kids, if that's how I want it. And then I say, the grantor or the settlor retains a special power of appointment to reallocate the interest of the remainder beneficiaries. Listen to the whole thing, between and amongst the named beneficiaries, my lineal descendants, and trusts for their benefit. This does two very important things for us. If one of my three darlings has a legal liability and calls me that the third divorce is about to happen, because mama retains the ability to yank that interest away, their creditors cannot go after it. If I retain the keys to make changes to the identity of the beneficiaries, their interests are not legally vested. They're not frozen. So it's protected from their creditors, from their divorces, a car accident, bad business venture. And this will also protect my kids if I die before my husband. And I predict he would be remarried within 3 months. No doubt about it. He doesn't know where anything in the house is, and he needs a lot of support and help. He would be remarried, and what is she going to be saying from day one? Put me on the house. Put me on the house. Well, the language to make changes was what? Between and amongst our lineal descendants and trusts for their benefit. So the go-go dancer does not meet that definition, and this trust blocks a surviving widow or widower from being tricked. From being tricked by a con man or woman, or by a spouse or a pretend spouse. And that's a very important consideration. A fair percentage of us will have some cognitive impairment, and these are like erecting bumpers around the car so people don't get hurt. Yes.
The two people that let's say you wouldn't have in trust with you, how do they get paid?
Okay, I'm not following you. You mean the beneficiary?
The beneficiary, the person you put in charge to help.
Oh, your trustee would typically not take money. No, your trustee is typically a close friend or family member. It can be a clergy member. They will typically do this as a courtesy.
Oh.
And if it's a beneficiary, under the old law, you couldn't have the same trustee and beneficiary. Now you can, and they don't want a commission for acting as trustee because that would be income taxable to them. Whereas in their role as beneficiary, they take everything automatically with no taxes, no income taxes. So the receipt of an inheritance is not subject to income taxes.
Amber, do you suggest I can get a will?
Well, listen, it's like Goldilocks and the three bears. So the first bed is we don't have anything, okay? And our estate and asset protection planning are crossed fingers.
I have one son, one person.
If we have 10 or 1, they have to go through the same probate. So what exactly is probate? The surrogate's court judge in Queens County or Nassau County or New York County has to physically look at the will and has to make sure that the staples weren't removed and send notice to anyone I may be related to. So when you read the daily news and the little micro print announcements that we all gloss over, that is saying, please be advised that Ann-Margaret Carrozza's will is being offered for probate. if you want to know how much she had, or, what the skeletons in her closet are, in case there are some that the Daily News didn't get to and you're curious. You would go down to surrogate's court where everything is totally open and available. And the probate in New York State has to be open for a minimum period of 7 months. I am doing this 26 years. I've never seen one wrap up as quickly as 7 months. Okay, and who is paying the taxes, who's paying the insurance, who's paying the co-op, maintenance? So probate is no joke. Is it better than having nothing? Yeah, having nothing, we're in court for 2 years. That's an administration proceeding. Even if I only have one child, that child has to prove the non-existence of other siblings. So it's like a tortured logic system. And if you're out of an administration proceeding in under 2 years, I've never seen it happen.
So your answer is yes.
Yes.
Good back. Nassau County versus Wake County for probate courts, but they backed up after COVID.
Well, I think, we have a judge with us. The backup, there's always been a backup, and backup due to COVID is not insignificant. So everything is taking longer in Florida. You can't predict. You can't predict. Sometimes, we get lucky and it happens in 8 months. 8 months would be lucky. Yes.
Could I get a clarification of I clearly understand capital gains, and you said the inheritance tax threshold is 6.1.
In New York State.
Right, so if there's great capital gains on the house, as long as it's below that threshold, no inheritance tax.
Yeah, as long as we're below the current threshold, which if you're taking notes and you put it in the dining room buffet and you pull it out in 3 years, this may or may not still be the case.
Right.
Right now it's 6.1, meaning if we're under that, we avoid capital gains and we avoid estate taxes.
My parents' house was in the irrevocable trust, and when the last parent died, it passed to me. And I was told I better get when you assess the value of
Yeah, an appraisal.
appraisal at the time of the death. Why would that matter when it's well below?
Because you want to be able to show that you got a step up to the fair market value as of the parent's death.
Right.
If you hang on to that house for 2 years and sell it at a gain, how is the IRS going to know what your new score was? You have to have it marked at the time of death.
Okay.
You don't have to do an appraisal if you plan on selling within a year, because the IRS will assume that the ultimate sale price was the date of death value. If you're planning to hold it for a period longer than a year, get an appraisal.
Can I get a retroactive appraisal?
No, the best you can do there is an opinion letter. And you would call Adriana Rodriguez with Legaz Realty, and they can do an opinion letter as to what the likely fair market value was going backwards. Yeah, better than not doing it.
Thank you.
Yeah.
I'm deviating, but yesterday I spoke to a friend. He got lucky and unlucky in the sense that he owns a co-op. He was allowed to rent a sublet at one time. And as soon as the person moves, whatever, you have to sell it. He got a tenant who stayed for 30 years. But it's not that he stayed, he died in the apartment. So they just found him in July, et cetera, et cetera. So everything is with the public administrator. And it's already been since July, and he can't get access to his apartment to sell it. So are you telling me it could take 2 years because of the person who died in the apartment?
Oh, that situation is just bonkers.
Yeah.
And you're looking at a long-term thing. Yes,
And I was gonna ask, is there a federal estate tax
Yes.
besides the estate tax?
yes. So just like when we file our income tax return, we need to deal with federal and state. The current federal threshold is 12.1 million. Don't roll your eyes at that one either, because it is scheduled by its own terms. So this is not a maybe. Under the Trump tax cuts, where the estate tax threshold went to 12.1, it is scheduled by its own terms to come crashing back down in 2025 to 5 million. Indexed for inflation.
Wow.
You know, but these things are, you know, they're not written in stone, and a different administration is going to do a different thing, which is why it's critically important to develop a relationship with someone that you can sit down with every couple of years or so and talk through the situation. Do I need to update my will because it's 15 years old? No, not in a vacuum. If I still like the people I named in it, no. If it was a valid will 15 years ago, it's a valid will now. But if any of my beneficiaries have a problem, if my husband is in a nursing home, do I want him to be the primary beneficiary? No, because if something unexpectedly happens to me first and everything is dumped into his lap, the nursing home is going to get it. So I should revise my will to say, if I am survived by my husband, I leave everything into the Ann-Margaret Carrozza Trust for his lifetime benefit. Now, I'm not disinheriting him and hoping that the kids do the right thing by him. My assets have a soft landing in the trust, and the trustee can utilize trust assets for his lifetime benefit without Medicaid taking them.
Regarding trustees and regarding persons who are either about to be or have been designated as powers of attorneys, what would be some of the most obvious risks when you assume that responsibility? Because a friend of mine raised that question to me. I said, well, look, this guy's in bad shape. He's got all kinds of things to work. Don't know what lies ahead for him. He's only got one other person. The rest of his friends passed on, families.
Okay, so if I could, I'll answer the first part of the question. What kind of risks are there for a trustee? And that's an excellent question. The law in New York State is pretty strict. And it says if I'm a trustee, I have to do this and I don't have to do that. But a properly drafted trust will extinguish a lot of routes to liability for me. For example, it will say that the trustee does not have to have a diversified portfolio. That's a requirement for trustees. But what if the trust only has real estate, which most of these trusts do? That's not a diversified portfolio. So one of the beneficiaries can sue the trustee unless within the trust, I say they don't have to have a diversified portfolio. So we look at all of the possible routes to liability for the trustee, and we do away with them within a properly drafted trust. Okay, so the bottom line and the last thing we'll say on the trust issue is that if it's a good one, there's nothing you can't do that you could do with the property in your own name. So it's just a matter of constructing it based on your individual situation. Yes.
Can you discuss long-term care insurance?
Anyone interested in that topic? Long-term care insurance?
Besides the real estate,
I'm sorry?
besides the real estate, how do you like?
You know, he said long-term care insurance, and I asked the group, is anyone interested in that? Okay. The number one reason people don't have long-term care insurance is what? It's very expensive, number one. Number two, they are allowed to increase the premium. So you know, it's not a fair playing field. If I, you know, buy my policy when I'm 64, before I hit, you know, what I think is a big birthday next year, and I can swing the premiums comfortably, there's nothing stopping that company from increasing the premium 8 years later when I'm closer to actually needing it. And then if the pressure is too much and I don't go along with the increases, what happened to all of my premiums? Gone, out the window. So I am not telling you to dismiss the notion of long-term care insurance and rely on Medicaid, because Medicaid will not be there in its current lovely form in even 10 years. So definitely become conversant with the long-term care policies that are out there. For those folks who have some liquid assets, you might consider a new type of long-term care insurance policy based on a whole life insurance model. So I take 50,000 or 100,000 and I buy a whole life insurance policy that can have a care rider on it. So if I get sick and need help with activities of daily living, I can pull benefits from this policy. If I'm lucky and I don't need care and I die in my sleep 1 year, many years from now, I hope, my named beneficiaries get the death benefit. So it's terrific. If I buy this thing and I get short on cash later and I want to sell it, they have to buy it back from me, the company. The only caveat is that the company, whether it's MetLife or Genworth, they get to keep the interest that have generated on the money. So it's something nice for you or your adult children to talk to your financial advisor about. It's a good option. We may have time for a few more questions, but I just want to take this moment to thank St. Luke Church and Father Costello for allowing us to be here and share a lot of timely and important information. Today is about, you know, developing a connection. If you come to me, great. If you just want to call me and ask a question, I'm always happy for that. And our co-sponsor for today, Gleason Funeral Home, they are the absolute best. Now, when we have a tragedy, the human reaction is we want mama to go to where dad went to 20 years ago, but where dad went to 20 years ago, it is now owned by a private equity conglomerate. One of the few family-owned funeral establishments is Gleason's, and they are such terrific neighbors. And I'm going to tell a story that John is sick of hearing. But a number of years ago, and I tell this story in the book, but I give you a fake name in the book, John. There was a woman in downtown Flushing. She went to St. Mary's. She was a daily communicant, and she never married, lived in her childhood home. And I did a home visit for her because she couldn't get out, and I was just awestruck at, you know, it was like 80-year-old furniture that was pristine without little kids with Legos and truck scratches. Everything was beautiful. And she wanted her estate, naturally, to go to the church. Okay, we drafted the will, and as an aside, she had forgive me, the ugliest cat I've ever seen in my life. And she loved this cat so much. And so we did the will, we say goodbye. 2 years later, a guy calls me and he says, I'm Catherine's friend. We'll call her Catherine. And she wants to redo her will to leave me her house. So, and I stifled, saying something fresh because I thought then he's gonna take her somewhere else. So I said, okay, that's great, but you understand, sir, that I need to hear it directly from her. So I think he must have pushed her in the car and they pull up to my office in Bayside. And the two of them are sitting in the conference room. The receptionist tells me the client is ready. I come in and I asked the guy, I said, forgive me, but I need to speak with her alone. He goes in the waiting area and I asked her, who is this? And she said, I don't really know. He comes around a lot. Now, she was starting to be a little foggy on the details. She said, he promised to take care of my cat if I leave him the house. I said, now I'm panicking. She's sitting there and I thought, you know what? I'm going to call John Golden. I did. And I said, hey, John, how are you? How are you? Listen, this may sound like a strange question and I'm crossing my fingers because she's right there. Would you help me place a cat for someone if they passed away? And he said, you know what? Yeah, absolutely. I'll take the cat. And you had your dad at the time and you said you'd be some company for him. So she hears this and now she's calm, hang up with John Golden. And she asks, what do I tell the guy outside? I said, tell him whatever you want, but that the lawyer is keeping the new will for safekeeping to try and get him off of your back. So lo and behold, she did pass away. I called John and man of his word, he went there to pick the cat up. And I think there was a bad outcome. He scratched you and ran away. But anyway, totally family run, stand-up neighbors and people who are there for all of us. They support community organizations. And my family has been dealing with Gleason. I don't think you were there, but I looked at my great-grandfather's death certificate from 1927, and it was, they called it Gleason's funeral parlor. I don't know when that nomenclature changed. But I do want to thank Gleason. I want to thank Adriana Rodriguez of Legaz Realty for moderating the Zoom. And we're going to try to have a recording. And we're very lucky, and it's kind of silly that Greg Sullivan, a media mogul and former 60 Minutes producer, I prevail upon him sometimes to help me out when he's not busy making movies and running around with beautiful people. So he's going to make a recording, and anyone who wants the recording to share with someone else, reach out to my office. But a good starting point for this whole Michigas is my website. I keep a lot of timely information on there, some free forms, an initial questionnaire if you want to get the ball rolling, and that's myelderlawattorney.com. So with that, thank you so much for having me. So should I jump on now for the Zoom? Great. How did that work out? So I have to follow everything on my own. I texted her. I had texted Marion this week and she said that, yeah. With this whole thing with them now. I know. Oh, I mean, I saw the people every day and then one day he was in there. So it was crazy. But people training for the best. Me too. I just retired. Don't retire. That's right. Are we good?
Yes.
Okay. But anyway, I'm gonna be giving you a call to follow up with my.
I've been thinking about you, Lorraine.
Yeah, I was. I'll tell you all about it. I'll call your office.
All
and
right.
make it a point.
Oh, no, we're not good for that. Hold on a second.
Okay, wait. Hi.
Nice to meet you.
Oh, I wish you.
I think we might have to go.
That deal with there. Yeah, where? Oh, yeah, deal